The Ministry of Justice has an important role to do with respect to the tackling of crime reduction, alternatives to incarceration, rehabilitation of offenders, as well as breaking the cycle of recidivism within our justice mandate. Now, central to these measures used to protect the public from violent offenders are our parole and sentencing regimes. The ministry is seeking to address some of the challenges present in the administration of and the responses to the offenders within our community. And to this end, we are looking seriously at proposals that aim to tighten reins, fill gaps, and further protect the community. The Ministry of Justice measures that were articulated by His Excellency in the speech from the throne included an undertaking to table legislation designed to mitigate the risk that an inmate granted parole will reoffend. In further developing this legislative initiative, the parole regime was reviewed in order to specifically address perceived and actual deficiencies within the system. As a result of a very, very thorough review, which was undertaken by our policy team in collaboration with the Department of Court Services, the Department of Corrections, as well as the Judiciary, Cabinet recently approved a set of legislative proposals designed to enhance the parole regime. To this end, legislation will be forthcoming, which will introduce a tiered system of sentencing, which will effectively revise the minimum time served for eligibility considerations with respect to parole as represented in the speech from the throne. Further, Cabinet has approved a legislative proposal to permit judicial discretion to be applied to reflect the circumstances of a crime as it relates to the grant of parole. To this end, a re-entry court will be established to utilize judicial authority for release of all offenders who are serving a term of imprisonment of 4 years or greater. The parole board will be empowered to grant or revoke licenses as well as parole for persons who are serving sentences for up to 4 years of imprisonment. The benefit of the reentry court regime will ensure that the intent of the sentencing magistrate or judge is realized, and it ensures completion of mandated programs as well as the intended minimal sentence of imprisonment. To this end, there is a seamless system that enhances strategies to track, monitor, and enforce conditions through judicial monitored case management practices, which minimize the offense and the risk of relapse. The name in and of itself denotes continuity and positive reentry of offenders, which involves incentives as well as sanctions and affords supervision of all offenders post-release from custody. Returning now to the throne speech initiatives, one of them that you'll recall that was in the throne speech specifically spoke to the mitigation of the risk that an inmate would reoffend once parole has been granted. And in order to more rapidly deal with this particular issue, we are looking at amendments to the legislation that will change the current system, which you may recall provides for an unmitigated system of eligibility for release after a person has served a 1/3 of their sentence. We are looking to introduce legislation that will provide for a tiered criteria with respect to the person's eligibility for parole. This will address reoffense risk as well as promote continuity and consistency, as well as to engender more public confidence. Now, in other jurisdictions, such tiers have been used for eligibility with respect to rehabilitation status, and they have proven very successful. The severity of the offense, the response to and the completion of mandated programs such as anger management, drug treatment programs, and the like, as well as the offender's history, will be an indication of the propensity for that individual to embrace change of behavior as well as attitude. So, for example, the tiered system will work as follows. A person that is convicted of an offense where the sentence is 2 years of imprisonment, again, this is an example, there's no aggravating features such as violence or factors such as that. The person has completed the mandatory required court programs such as drug treatment, etc. That person will be eligible for parole after the completion of 1/3 of their sentence. On the other hand, an individual that may very well have been sentenced to a term of imprisonment of 5 years or more, aggravating features such as violence, the use of theft, robbery, etc., those persons will not be able to be considered for eligibility for parole until the completion of 2/3 of their sentence. The implementation also I'd like to speak of is with respect to a review court. And a review court will be there to address all individuals who have been released on parole. And it will operate on a set timing every month, and it will help to augment this new scheme that I've just spoken about concerning the reentry court. So appearances alone will act as a catalyst to positive behavior, and it will hold the offender as well as the officers to a greater level of accountability. Now, this will involve regular reports, intermittent short periods of incarceration, such as a weekend or up to 2 weeks, as sanctions that will be merited out, rarely, as well as incentives will be provided for good behavior and conduct. And the ongoing attendance is based upon responses to supervision as well as the programs, whereby most positive results and responses will result in less frequent appearances, but monthly reporting will continue. Now, what I mean by this, the review court will operate similar to the drug treatment court, which we've seen has a 95% success rate. And the main impetus behind that success, not only because of the programs that are provided for those individuals, but the constant review, the constant reappearing back in front of the sentencing judge or the magistrate for there to be a checks and balances per se. And if circumstances exist where that individual has failed to honor some of the conditions of their parole, then that sentencing magistrate and or judge will have the power to effectively send them back to prison for a weekend or depending on the circumstances. And likewise, if it shows that the individual is adhering to all of the conditions of their parole, the treatment programs, etc., then the frequency of their monthly appearances will also diminish, but that doesn't reduce the fact that there will still be monthly sessions and reviews submitted to the court. So we'll operate similar to the drug treatment court program. We don't anticipate that that will cause any more of an administrative or any other financial impediments, because it can be tied directly to the monthly arraignment courts for the matters that will be dealt with on indictment in the Supreme Court, or alternatively following a plea court session in the magistrate's court. I also would like to say that the drug treatment court program, which I've spoken about previously, has demonstrated a lot of success, and we will mirror the review courts on that same process. And we've noticed also that we continue to provide administrative interventions that have been implemented, which will include reinforcing our effective collaboration that currently exists between the departments within the ministry as well as across the government. That collaboration is obviously exhibited here today when we have the Commissioner of Prisons as well as the Director of the Department of Court Services. And these collaboration addresses matters relating to reports, interface issues, legislation, communication, and planning. And in particular, a tripartite meetings were established and resumed this past September involving the Commissioner of Corrections, the Director of Court Services, and the Chairman of the Parole Board. To further address concerns pertaining to the parole regime, ministerial directions have been given to the Parole Board in exercise of my powers pursuant to Section 7 of the Parole Act, Board Act, 2001, as to policies that I am directing the Board to implement concerning the performance of their functions. The directions are aimed at ensuring that the Board takes into consideration evidence of gang affiliation as well as the offender's level of involvement in the gang prior to imprisonment where such evidence is supplied by the relevant authority. And in addition to that, the risk to public safety must also be considered by the Board where an inmate is identified as a prolific priority offender. The Parole Board has also been directed to consider the use of electronic monitoring for parolees as a condition of their release in appropriate circumstances. Now, whilst increased collaboration will strengthen the administration of the parole regime, legislative reform is necessary to realize our commitment to rehabilitate offenders. This unwavering commitment to rehabilitate offenders, which involves the inmate rehabilitation programs which are currently being administered within our corrections facilities to to help to address issues such as anger management, violent offenders, life skills, parenting skills, GED certification, and the list is endless. And if you want further details concerning the programs that are on offer to assist to rehabilitate our offenders, then we do have the Commissioner, Mr. Lamb, who could speak to that further. In closing, I'd like to emphasize the fact that the Ministry of Justice continues to build on the legislative and administrative framework that underpins our mandate and operations. And we have adopted a proactive and considered approach in the identification, development, and implementation of measures to address criminal activity, ever being mindful of the constitutional rights of individual citizens and the responsibility of this government to ensure public safety. I thank you.